Good day, Your Honor. Today is for the initial presentation of evidence for the prosecution, but since the accused has admitted the killing of the victim by invoking self-defense, we respectfully submit that the burden of evidence has shifted. The prosecution therefore move for reverse trial, Your Honor.
Granted, we shall observe a reverse trial. The defense shall present its evidence first. Under Rule 131, Section 1 of 2019 Amendments to the 1989 Revised Rules on Evidence, burden of proof is the duty of a party to present evidence on facts in issue, necessary to establish his or her claim or defense by the amount of evidence required by law. Burden of proof never shifts. The burden of evidence in turn is the duty of a party to present evidence sufficient to establish or rebut a fact on issue, necessary to establish a prima facie case. The burden of evidence may shift from one party to the other in the course of proceedings. In a criminal case, the burden of proof is always on the prosecution to prove the guilt of the accused beyond reasonable doubt. It never shifts. The burden of evidence, on the other hand, may shift from one party to party, as when in this case, the defense is raised by the accused effectively establish the charge of killing. The burden of evidence thus was transferred to the accused to prove the killing was justified. Are you ready with your witness, Attorney Siti Ania?
Yes, Your Honor. The accused is ready to testify.
Call your witness then, Counsel.
With the court's permission, the defense called the witness, Ms. De La Cruz, to the witness stand.
Your Honor, may we know if there are other defense witnesses present in court? And if there are, may we move for their exclusion, Your Honor?
Do you have other witnesses to present in court, Attorney Siti Ania?
Yes, Your Honor. Our expert witness is present. The psychotherapist of the accused, Dr. Ramon Villa. We respectfully moved that Dr. Villa be allowed to remain in the court as his presence during the accused testimony is essential to the defense cause.
The expert witness may remain in the courtroom. Under Rule 132, Section 15 of the new Rules on Evidence, the court motu proprio or on motion shall exclude other witnesses of a party so that they will not hear the testimony of such party except the following: a natural person who is a party, a representative of a juridical person who is a party, a person whose presence is essential to the presentation of a party's cause, or a person authorized by the statute to be present. All offers must be made orally.
Ms. Witness, do you remember executing a judicial affidavit in relation to this case?
Objection, Your Honor. The counsel is already asking question to the witness when she has not yet offered the testimony.
Sustained. Attorney Siti Ania, offer the testimony of your witness first. Under Rule 132, Section 35 of the 2019 Amendments to the 1989 Revised Rules on Evidence, the offer of the testimony of the witness must be made at the time the witness is called to testify. All offers in evidence, including documentary and objective evidence, must now be made orally.
Your Honor, we are now offering the testimony of the accused to confirm the truthfulness of his statement in his judicial affidavit. Marked as Exhibit 1 for the defense, specifically to prove that the killing of the deceased Pedro Torres was an act of self-defense on the part of the accused. The accused will also testify on his story that of decades-old quarrel between his family and that of Pedro Torres, which has caused him to suffer serious mental and emotional stress necessitating psychotherapy. Okay, now Ms. De La Cruz. In answer number 8 in your judicial affidavit, you stated that according to your mother, your family's quarrel with the family of the deceased started more than 40 years ago, even before you were born. Do you confirm that? And you stated further that the quarrel started way back when the father of the deceased refused to pay your mother's money which she lent to him. Is that correct?
Fiscal, the proper ground for objection is lack of first-hand knowledge. When the witness is testifying in a fact which is not based on personal knowledge, what was previously labeled as hearsay is lack of personal knowledge. Under Rule 130, Section 22 of the new Rules on Evidence, the objection is sustained on ground of lack of first-hand knowledge. Under the new Rules on Evidence, the concept of hearsay has changed radically, as defined under Rule 130, Section 37 of the 2019 amendments to the 1989 Rules on Evidence. Hearsay is a statement other than one made by the declarant while testifying at a trial or hearing, offered to prove the truth of the facts asserted therein. It includes an oral or written assertion or a non-verbal conduct of a person if it is intended by him as assertion.
Now, Ms. De La Cruz, marked as Exhibit 4 is a photograph showing that the deceased is brandishing a bolo. Can you tell the court now when and where the photograph was taken?
Objection, Your Honor. Best evidence rule.
With all due respect to the fiscal, Your Honor, the rules on evidence includes a photograph in the definition of the documents under Rule 130, Section 2, and under Section 4, the photograph itself is considered as original.
The objection is overruled. Attorney Sitiania is correct, but the proper ground under the new Rules on Evidence is the original document rule. Under Rule 130, Section 2 on the new Rules on Evidence, a document now includes writing, recordings, photographs, or any material containing letters, words, sounds, numbers, figures, symbols, or their equivalent, or other modes of written expression offered as proof of their contents. Under the Section 4 of the same rule, an original of a document is the document itself or any counterpart intended to have the same effect by the person executing or issuing it. An original of a photograph includes the negative or any print therefrom.
Ms. Witness, you further narrated in your judicial affidavit that the deceased stood in front of your group and said these words, "Lasing na ako. Ilalabas ko na ang lahat ng galit ko. Hindi niyo na ako mapipigil." Ms. Witness, do you recall this? Objection, Your Honor. That is a matter covered by the attorney-client privilege. Objection, Your Honor. Irrelevant. Besides, that is an attack on the character of the accused, which is not allowed in the rule. Objection, Your Honor. That is not taken up in the direct examination. It was not even mentioned in the judicial affidavit of the accused.
Objection, Your Honor. The dead man statute prohibits this particular testimony.
Overruled, Fiscal. The dead man statute does not apply in this action. More importantly, the statement is clearly admissible as a declaration against the interest under Rule 130, Section 40 of the 2019 amendments to the 1989 Revised Rules on Evidence, which a declaration made by the person deceased or unable to testify against the interest of the declarant. If the fact asserted in the declaration was at the time it was made so far contrary to the declarant's own interest that a reasonable person in his or her own position would have made the declaration unless he or she believed it to be true. Fiscal, do you wish to cross-examine the witness?
Yes, with Your Honor's permission.
Go ahead.
Miss De La Cruz, are you related to the barangay chairman in your barangay?
Objection, Your Honor. That was not taken up in the direct examination. It was not even mentioned at all in the judicial affidavit of the accused.
Overruled. Rule 132, Section 6 of the 2019 amendments to the 1989 Rules on Evidence now permits cross-examination on any relevant matter and has deleted the restrictive phrases, any matter stated in the direct. Please answer the question, Miss Witness.
Miss De La Cruz, do you remember after your meeting before the Lupon, you and your lawyer spoke with your uncle, the barangay chairman, and the chairman of the Lupon, and advised you to end your quarrel with the deceased?
Objection, Your Honor. That is a matter covered by the attorney-client privilege.
Your Honor, how can it be considered privileged and confidential when it is made in front of a third person, the barangay chairman?
Counsel, please remember that the attorney-client privilege may be waived by the client who is a witness here. In light thereof, he may choose to answer. In any case, the objection is not valid because, as pointed out, the communication is not pointed out to be kept confidential as it was made in the presence of other people. The witness can answer.
I will move to another point. Miss De La Cruz, is it true that you were previously convicted by another branch of this regional trial court for illegal possession of firearms?
Objection, Your Honor. Irrelevant. Besides, that is an attack on the character of the accused, which is not allowed under the rule.
Overruled. Under the new rules on evidence, particularly Rule 132, Section 12 of the 2019 amendments to the 1989 Rules on Evidence, for the purpose of impeaching a witness, evidence that he or she has been convicted by final judgment of a crime shall be admitted if the crime was punishable by penalty in excess of 1 year or the crime involved moral turpitude regardless of penalty. The amendments are designed to address the twin problem of docket congestions and delay by ensuring speedier and more efficient proceedings. They also take into consideration the advancement in technology, lessons from local and foreign jurisdiction, and our rich jurisprudence. Overall, the amendments are designed to ensure the end of justice will be served by more efficient judiciary.